Welcome to the DWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the DWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 176 of the DWI Guy podcast. On today's episode, I have a very special guest, Adam Everett, on the podcast. Adam has a criminal defense practice in Conover. Before he went into the criminal defense side of things, he was a prosecutor. But before sitting at either table, he was a magistrate judge in Wake County. And on today's episode, we get to look behind the curtain of what happens at a DWI initial appearance when somebody is arrested and taken into custody by an officer. They go to the jail, they go to the detention center and are brought before a magistrate. What does that look like from the magistrate's perspective? Well, Adam, who served in that capacity and did hundreds, probably thousands, based on our conversation, of DWI initial appearances as a magistrate judge, is going to let us look behind that curtain on today's episode. Had a blast talking with Adam, learned a lot, and I hope that you do the same.
Now that we're recording, I'll just say it again. I haven't gotten my lighting quite 100% right, but that's okay. And as I was telling Jake before the recording began, that's sort of how it was as a magistrate in the Wake County Detention Center. We weren't so much concerned with the lighting, and I think that's kind of ironic. You just kind of roll with it. And I found that to be true as a magistrate. And but there are certain legal rules that certainly apply. And that's and of course, reading the syllabus and everything for this podcast. I'm really excited to be here. This is the first podcast I've ever done.
Well, I'm super excited to have you on. I think that this is going to be just a blast of a conversation. I feel like the what goes on during that initial appearance over at the jail is such a black box. It's something that from a defense attorney side of things, we are trying to figure out was there a right violated, was everything kind of done appropriately over at the jail, but certainly in terms of like the space and conversation and what this kind of typically looks like on a day-to-day basis, I really think that is a real area of veil, like we're getting to peek behind that veil. So I'm just super excited to have you on the podcast, Adam. And kind of before we get into the magistrate end of things, I'd kind of like to maybe just step back a little bit and kind of have you kind of explain what was the reason that you went into law school in the first place, and then ultimately kind of went down the path into the magistrate's office. So yeah, if you would mind to kind of just share a little bit of your experience into law school.
Sure. Yes, I'd love to. So, I mean, one of the main reasons I went to law school at UNC Chapel Hill, which is where I went to undergrad, I was involved in the Attorney General's staff, and we were tasked with both prosecuting and defending students who were charged with honor code violations. And so it was a very interesting role that and I'm not sure if it's still this way or not, but the Attorney General staff at UNC was tasked with both roles, both prosecuting and defending students who were charged with honor code violations. And so that's where I got my introduction, and I thought that it might be more prosecution oriented, and I found myself more on the defense side at UNC, and really enjoyed that. I do have another.
Were you kind of sitting in the role of like judge there, or like what was your role in that process?
My role was the role of advocate.
Okay.
And yes, and so we advocated on behalf of students
And is this in real cases then? You're talking about like where there's actual honor code. This is not like a mock courtroom type thing. This is the real deal.
It was the real deal. They were real cases, and there's some that I wish that I could discuss. But based on my understanding of the the education rules and things, there's some unique situations where I better not disclose certain things about that. However, I found it to be fascinating. I wasn't expecting necessarily when joining the student attorney general staff to be on the defense side. And there is a lawyer in my family. He's a little bit older. I can go ahead and give a shout out to him, Brady Vinoy. He is a DWI focused lawyer in and around Charleston, South Carolina.
That's awesome.
And he went to the Citadel and went to the Charleston School of Law, and he's the oldest young man in our family, and so my parents and they were always, of course, having me look up to him, and I really did. But to the extent that Brady sees this, I know he's defending a lot of DWIs, or they call them DUIs in South Carolina. I commend him. And anyway, that was sort of my introduction into defending folks against certain allegations from the state government against them, was actually working for the Attorney General staff at UNC.
Yeah, that's a super cool way to kick things off. What during your law school experience, if anything, kind of put you in the path of the criminal world? Was that like the orientation going in, or what was the kind of path into the criminal world?
I think every kid is interested in like cops and robbers.
Oh
so
yeah,
to
for
speak.
sure.
And I put that in quotation mark, air quotes, cops and robbers. So that was really what I needed. The adrenaline component. I just never was. It would be hard for me to do tax law or something like that.
Yes.
So,
Oh man, just hearing that sounds miserable.
and I'm glad that we have lawyers who do that and that thrive on that. But without that added natural adrenaline component of police and those that they pursue, it would be hard for me to do law, I think. And so
Yeah, for sure.
Mm-hmm. So I found that to be just something that's naturally stimulating on either side. I worked at the Durham County District Attorney's Office as an intern in law school, and at the Wake County DA's office as an intern in law school. And both of those experiences helped a lot to get me into the public sector arena. That's where I've naturally gravitated.
Yeah, I feel like there's really few places better to intern during law school than at the public defender's office or the DA's office. Just the kind of like seeing things in the courtroom and in the, depending on the county during your second year with that like second year practice rule, there's some places where you can get some kind of meaningful work in, even if you're only there for 8 weeks or something. I mean, there's definitely some real opportunities to get your feet wet a little bit in a criminal courtroom. So that's a great place to be in, on either side of the table. I mean, just those lawyers that are in the courtroom every day, shadowing them, there's just so much to be learned.
Absolutely. And both of those offices had very robust third year practice rule teams. And, I can tell you that the Durham County DA's office was in a period of transition at the time. Judge Leon Standback was the interim district attorney. And then I worked under him. I also worked under Roger Eccles, who became district attorney. They were both excellent mentors, and they really had a steady hand of leadership over that office. And they let us try a lot of cases. And
yeah, that's great.
And the same, I would say the same about the Wake County DA's office as well. So.
And then from your time in law school, kind of into, once you pass the bar exam, what was kind of the career trajectory at that point? Like what were you looking for, and kind of again, what ultimately led you into the role of being a magistrate?
Public service. I was oriented into public service, especially after experiencing how rewarding it could be to have a career as a lawyer in public service. So after I passed the bar exam, I started volunteering as an assistant district attorney in Durham County. It was unpaid at the time, and there were three of us who were doing that. And so, um, I my plan was to stay in Durham until a paid position opened up. But I was dating someone at the time, and she was subscribed to the state job employment website. I guess they send out state job opportunities periodically. She let me know there was a magistrate position that was open in Wake County, and I applied for the job. Basically, knowing that it was a very competitive job marketplace at the time, thinking it would be good interview experience. But knowing that it was a public service job, and a career that would still have me involved in the criminal justice system. So I thought, well, this will be good interview experience.
That's awesome. Yeah, I mean, I think that it's interesting to even like have a position that you're working really on a volunteer basis like that, where that's kind of the shoe in. But I feel like there's so many kind of similar positions that I had either during the first or second year of summer. I know there was some attorney friends on my end that were doing something similar at the DA's office. And it's just such a coming out of law school after having all that time and sweat equity and the anxiety of going through the bar exam, ultimately to really just still struggling. Like, I mean, it was just on my end, hundreds of applications that were sent out, like very little interest in terms of anybody looking to hire. And so it's just one of those things that's such a wild space to find yourself in after putting in that much time and money and energy into something, being like, well, I guess it's better go find something, because there is not this demand. I graduated in 2009, and it was not, there was nobody was knocking on my door.
Well, yes, I understand. And this was 2014, and it was, gosh, you were coming out in the midst of quite the recession. And I think the economy was just starting to really recover about the time that I graduated, although it had not yet fully recovered. And so,
and I think that the lawyer market at that time was really strange, because there was a lot of lawyers that had their own space, that went to work for other firms, and people that were in the real estate industry that got hit so hard that went into criminal defense or other practice areas that there was just more work to be done. So it really was like a wild time in terms of the legal industry. I mean, at the time, I had very little knowledge of this. This was, I'm not somebody that really follows the news at all, and so it's like more somewhat getting this information from family members or other things, or looking back and being like, man, that was kind of a wild time. But yeah, certainly in 2014, it was still a pretty wild job market, because you just kept having lawyers come out, year after year from law school, and people that had closed up shop and switched practice areas. So it was a competitive time.
It really was. Yes. And one of the ways that, I ultimately found out, just to answer your question, going back to the original question, I applied and received a couple phone calls from the clerk's office in Wake County. And it originally was posted as a part-time position, apparently 20 hours a week, and they raised it to a 40-hour a week position. I remember getting a call. I was in either Bass Pro Shop or in Cabela's over there in Garner, and they called and asked. They said, well, it's going to be 40 hours a week. Are you still interested? And of course that made me, even more interested.
Yeah, I'll stay. Yeah.
um, but yeah. And so, long story short, I ended up interviewing with then clerk of Superior Court, Lauren Freeman, who was about to run for elected district attorney. And I interviewed with then Chief Magistrate Judge Dexter Williams, and ultimately was very fortunate to be appointed to the position. So for those viewers who may or may not know exactly how becoming a magistrate works, the clerk of Superior Court, this is by statute, the clerk of Superior Court nominates at least two people to become a magistrate in their judicial district, and then the senior resident Superior Court judge appoints one of those two people to a term. The first term being 2 years, subsequent terms being for 4 years. But it's not as easy as just being hired. I mean, it's an interesting process because in some ways it is sort of like just applying and interviewing and being hired, but there are also these special hoops, statutory hoops that have to be jumped through. And so I thought that was kind of cool that, even when I was nominated by the clerk, there was still someone else that, it was up to the senior resident Superior Court judge, who at that time was Judge Donald Stevens, who then appointed me to fulfill a term. It actually gets a little bit complicated because I was appointed to fulfill the remainder of someone's term, and so I served throughout the year of 2014 after being appointed on or about September 15th of 2014, and then had to interview with a new clerk because Lauren Freeman was elected to be the DA. A new clerk came into office, Jen Knox, and so I then had to re-interview with her. This was for the second term, but it was not long after the first term.
Yeah, that's strange. That's interesting. What I'm trying to think. So in the counties that I've appeared before a magistrate in, generally, I've early on in practice, I had a couple of things in small claims court, but mostly it's related to some sort of a kind of DWI related issue. And so that, a civil revocation hearing or requesting the license to be returned after civil revocation. That's been the main time that I've kind of been in front of a magistrate as of recent years. But, I would say that probably about, 10 to 20% of the magistrates that I've appeared in front of have had a law degree. A substantial majority of the magistrates in our area haven't gone to law school. And so kind of two questions on that, in terms of Wake County, what did that look like in terms of the magistrates down there? What was, kind of the percentage of magistrates that had gone to law school? And then kind of secondarily to that, maybe a little bit of a longer question, what does the training look like for a magistrate? Because for magistrates, obviously, that have not gone through law school, there's a lot to absorb. And so what does that look like?
I can tell you, Jake, that at the time I applied to be a magistrate in Wake County, they were only hiring, this might be off the books, but I feel comfortable disclosing it. They were only hiring in general lawyers.
Okay.
So, and there was an incentive for lawyers to be magistrates. Of course, I found this out after I applied, but magistrates are paid on a certain level system. I believe it's levels 1 through 6. If I'm not mistaken, I'd have to go back and look at the statute on that. But if someone has a law degree and is a licensed North Carolina lawyer, then that magistrate starts out at level 4.
Okay.
In other words, they don't have to climb through the ranks as much as someone who may not have a law degree. We think of a lot of magistrates, to your point, as being retired police officers and things of that nature, and that's still very much I believe that that still very much happens. And it was pretty cool to be a part of the Wake County Magistrate's office because we had that full spectrum. We had, retired law enforcement officers, we had older men, and then women. And it was really the full spectrum of, ages, and people who really stayed there. That's another thing about, the Wake County Magistrate's office is that it was an office that was always open, so to
I'm
speak.
sure. Yeah. How many magistrates were in that office?
There were, to the best of my recollection, 26
That's
that were
crazy.
authorized by statute, and this is all again in the North Carolina General Statutes. And I believe when I joined, there were 26. One way I remember that is they gave us specialized license plates. So MJ 1026, I believe, was the lowest number that I had, but similar to the judges, J
Yeah.
10,
Yeah. Yeah. I
whatever
didn't
letter.
realize that.
Yeah. So in any event, I believe 26 magistrates at that time in 2014 were appropriated for Wake County. And
And
so there were a bunch, but there were never fewer than two in the office. And usually we had three or four at any given time. Some of my
yeah,
other guys,
that's such a different thing to be in a place that is that size. I mean, it's just a total different vibe than, most of the counties in and around Asheville area. It's, much smaller in terms of the size, and certainly a lot of places not fully staffed, around the clock. In terms of the training as you came aboard, or what's typical, what does that look like for somebody that's becoming a magistrate?
yeah, I'm glad you brought me back to that. There is a school that magistrates are sent to in Chapel Hill at the UNC School of Government, and that connected us with, of course, a lot of awesome resources. That's how I got to know, Jamie Markham, Jeff Welty, Jesse Smith, Shay Denning, all of those folks, through magistrate school, more or less. But yeah, there's 1 week of criminal law and 1 week of civil law. But really, I think magistrates are chosen for, and this is, not talking about me, this is something that goes back a long way. But, magistrates arose from the office of magistrate, came from the office of justice of the peace. And,
When we were talking about this on the phone, immediately I thought of Andy Griffith. That was
yes. And so, it's pretty cool. I mean, before the 1960s, it's my understanding, before the district courts of North Carolina were sort of unified by law, justices of the peace, were sort of like the local judges who could decide small cases and controversies, or certain cases and controversies, I should say. We now call them small claims and things of that nature. But in any event, and some older listeners may remember this, even lawyers. I mean, people had like AAA uh, for their cars, not just for, to call roadside assistance, but apparently it used to be a thing where the trooper would oftentimes have the alleged violator accompany them to see the judge, especially if they were passing through North Carolina and may not be from here. You might have AAA for bond purposes. Seriously.
Oh, that's interesting. Wow.
Yeah, and that's, something that's in days gone by and that we don't even think of anymore. But like the trooper may actually have the person right up front with them, which is still something you see today. Criminal defense lawyers out there, you watch your DWI videos and things, and the troopers, they still have the Andy Griffith phones literally in their patrol cars, and they still have people right up front. And that harkens back to certain days, when you would go see the justice of the peace. He might be the barber, and so for a few minutes, he would put down his barber supplies and speak to the trooper and whoever was in custody for the alleged traffic violation. Less than a DWI, of course. I know we're getting towards the big kahuna here, but yeah. So we had that training, but also the training from law school, I think, put us, well, it gave us a certain unique perspective.
Oh, for sure. Yeah.
I was really into criminal procedure at Campbell, and I was actually the elected attorney general at Campbell Law School. And anyway, only had to prosecute one honor code violation there, fortunately. But so that's kind of just leading back into the training. I think it's everything that the magistrate has experienced in his or her life, um, leading up to the decisions that he or she has to make.
Yeah, no, I mean, I think all that life experience makes a huge difference. And, going in and kind of getting that intensive 2-week training, I would imagine, after that, each county has their kind of own onboarding process, especially in a county as large as Wake. It sounds like, I'm sure there's a lot of like on site, training. But what did that kind of look like in terms of then, on the job training back in Wake County? And then, what did the kind of the typical night, give us like a
Yeah,
typical
yeah.
night of the magistrate life?
Well, I certainly wouldn't call it hazing, but but somehow,
You're not legally allowed to call it hazing, is
yeah,
that
yeah,
right?
certainly wouldn't call it hazing, but somehow every new magistrate ended up on the night shift.
Yeah, that's right.
Um, but no, anyway, I mean, and it was busy enough then where the night shift really was a thing. I mean, I started out working from 9 p.m. to 7 a.m. 4 nights a week, and a typical night was very, very busy. So in Wake County, at some point, before I was there were satellite magistrate offices, but in any event, when the Wake County Detention Center was created or built, um, all of the detainees, anybody who was arrested, came to one place in Raleigh, and that was where we were located. And so you had, of course, the Raleigh Police Department, Cary, Knightdale, Rollsville, Apex. You can just list them off. Zebulon, Wake County Sheriff's Office, North Carolina State Highway Patrol. You just imagine every agency, and
Yeah, that's
especially
crazy.
yeah, especially when I was working in 2014, there was a huge uh, DWI enforcement unit that was in place, or I should say, DWI enforcement, objective among the local prosecution. And so there was a DWI unit in Raleigh. Among the police officers at Raleigh Police Department, there was a DWI unit among the Wake County Sheriff's Office, and there was just a general greater focus on DWI enforcement at that time. I'm sure it's still big now, but it was bigger then. And so anyway, we had a lot of DWIs at nighttime, but it was everything. I mean, I think people think of magistrates, and sometimes people think of magistrates and they think, well, neighbors are trying to get warrants on each other. Well, that was literally like the minimum of what we did. I mean,
Yeah.
we handled involuntary commitments. The fax machine was running 24 hours a day, 7 days a week, with involuntary commitment requests from doctors, psychiatrists. That those had to be reviewed by magistrates. Uh, the issuance of search warrants, the issuance of warrants for arrest for folks who were not in custody. The course of the actual speaking with the defendant, or someone who's charged with the crime, setting their bond and things of that nature was probably the biggest thing that we did. I think it's important to make that distinction because, again, like I said, people think about magistrates as dealing with neighbor disputes, and while those are certainly important, that was the much lesser of our time.
Yeah, and I'm sure that, depending on what shift you're working, you're seeing more of some crimes, or kind of like more or less crime, just depending on that kind of time shift of being on, as a general rule. What in terms of the search warrants, what did that kind of look like on your end? Because I know that the only search warrants that I ever see in my practice are, search warrants to draw blood. But what was the kind of range that kind of took?
Everything from murder to attempts to commit murder, drug trafficking, packages, parcel interdiction, you name it. I mean, everything.
Yeah,
I would
that's
say
wild.
that, yeah, search warrants for blood, maybe 30% or less of search warrants that I issued. There were, and I don't want folks to think that magistrates are a rubber stamp either, because there were certainly times, and in reviewing a lot of materials that I kept from my time as a magistrate, I remember a lot of these incidents when I would deny probable cause or ask further questions. I think one of the most important things, kind of gearing it especially towards the audience of this podcast, is if you are scrutinizing a search warrant and you're a defense attorney, okay, that's been issued by a magistrate or by any judge for that matter, whether it's a district court judge or a superior court judge, it's important. So there were times when like a crucial fact would be missing. So I would ask the officer some questions, or the detective, or whomever it was, investigator or investigators, whoever was there. And sometimes like they couldn't fill in the gaps to provide probable cause. And so there would be no probable cause, and I would just deny the search warrant. There were other times when they could fill in the gaps. The applicant could fill in the gaps and provide for probable cause. And so it's very important that those additional facts be added to the application, because, I'm sure every listener of this podcast knows about challenging search warrants. You can only look at the four corners, right? So if a judge or a magistrate issues a search warrant based on asking the applicant a question that then satisfies that issuing judicial official that there is probable cause, but that is not memorialized in the search warrant somewhere, then it's not within the four corners of the document and the search warrant fails. So be on the lookout for that.
Yes.
Now that
Yeah.
I'm a defense lawyer, I can switch into that mode. If you're a defense attorney and you think something's missing, but a search warrant is issued anyway, be on the lookout for, did the magistrate, pencil something in? Did the applicant initial it? Did he or she date it? That actually became something that was litigated. I remember in a couple of search warrants I issued that, I was eventually satisfied that there was probable cause, but it was based on additional information that was provided during the interchange between me and the officer. And so that had to be memorialized in writing and dated. And I remember that being litigated in a drug case.
Interesting. Yeah. Yeah. That's super interesting. I think that that's such a powerful, reminder. I think it's easy to kind of skim through certain court documents or not really pay close attention. And specifically when it comes to like the DWI search warrants for blood, they are such, fill in the blank checkbox. It's such a checkbox oriented search warrant that I think it is somewhat easy to miss essential information, both for the officer and potentially for the magistrate as well. So I think that's one of those things that, it can just seemingly be like this other somewhat arbitrary piece of paper. But I think paying close attention to those details really is important, because there's a because of the fact that it's such a easy to fill in form, it's easy to miss stuff, I feel like. So
Yes, I agree completely.
well, in terms of like a person that came into the magistrate's office, and again, this kind of being a audience where we're focusing, again, we can go anywhere where we want to go. I get, like I said before, but with kind of the primary focus being DWI oriented. When you had somebody that was brought in front of you charged with DWI, what did that look like? And I mean, we can kind of go into the legalities of it as well, but even just from like a physical space and what was kind of like the typical demeanor of the person that was coming in front of you, what did that look like?
Well, that's a great question, Jake. And I mean and forgive me for chuckling. I'm just thinking about so many things with that question. It's pretty incredible to reflect on these experiences. So, I mean, I think to answer your question as an overarching, it's good to set the environment. So we were literally magistrates. We were, some folks may call us magistrate judges. I had one case go up to the Court of Appeals, and they did refer to me as a magistrate judge. So that was That was nice. But whether folks call magistrates judges or not, we were inside of the jail at the Wake County Detention Center, so there are no windows or anything of that nature. When you're on what they call the law enforcement side, which is basically where you see folks who are charged with all sorts of crimes, including driving while impaired. But to narrow it down to DWI, one good thing about working nights without a window was that you sort of lost track of time. And
that's right. It's like a casino in there. Not as much, maybe not as much fun, maybe more. But actually, to me, it'd probably be more fun.
Yeah, there were unexpected things happening. There were people, who would sometimes bond out as soon as you set their bond. But of course, jumping ahead of myself, the first duty of the magistrate, and this was a true duty, and I think that it was interesting. Your first goal is to determine whether or not there is probable cause to believe that someone has committed a crime. And so, I would always ask the police officer. There were Bibles there at every window, and of course, the window was, about this thick of bulletproof glass, but at the bottom or at the base, there's about this thick of where you could push papers through and things of that nature. And so every once in a while, somebody might get pepper sprayed, and there'd be pepper spray coming through that little slot. But most of the time it was papers. The first thing was for the officer to swear or affirm to his or her testimony. And, I'd say 5% of the time or less, I would find no probable cause. But that was something that was always documented. And it didn't just apply to DWIs, although it was mostly used in that context. There were times when I found no probable cause for an assault. Remember when, I believe a woman had poured some water on her husband, and had I found probable cause, she would have had to have been held with no bond for 2 days, and because it was on a Friday night, and she wouldn't have seen a district court judge for at least 2 days. It may have been on a Saturday night, but in any event, there are legitimate, uses for the judicial branch in those circumstances, and in any event. But more for DWIs, state troopers, to the extent that this is relevant. This is public information based on my experiences. A lot of times, if somebody blew like a .06 or a .07, and there weren't any other aggravating factors like a bad wreck or something like that, the state troopers would push the papers through that little slot, and they would say, unarrest, please. And that was their request.
Interesting.
Yeah, that was their request for the magistrate to find no probable cause and go ahead and end this case. I found that with the Raleigh Police Department, their general practice at that time was to go ahead and pitch for probable cause anyway, and let the magistrate decide which way it would fall. And so I remember, deciding whether there was probable cause or not. Most of the time, yes, there was. And then once you reach that threshold, then we actually had at the I don't want to go on and on for a long time here, Jake.
No. This is great. Hey, podcast listeners, I want to briefly interrupt today's episode to invite you to join me at the inaugural Freedom Fighter Summit in Asheville this October. This in-person only event is designed for growth-minded lawyers determined to take their criminal defense practice to the next level. Due to the size of the summit's venue, there are a limited number of seats available. Don't miss out on the incredible lineup of speakers and spectacular networking opportunity that this summit provides. For more details, visit www.miniclaw.com/summit. Enter the promo code NCDWIGuy, all lowercase, all one word, at checkout for $150 off your summit ticket. Look forward to seeing you there. Now back to the show.
But we actually had DWI findings checklists that we would fill out, and so I filled those out ab initio before the officer started testifying, or at about the time the officer started testifying.
And is that based on all the paperwork that you're looking through, or what is that based off of?
It was pretty much based off everything, including the testimony of the arresting officer.
Okay.
But yes, it did include all of the, and I'm looking here at some that I've saved. I mean, I saved over 200, and the reason I saved them was because that was the office policy was, I went to the DA's office, and it was, well, you could be subpoenaed for a null motion, and we may get into that in a little bit, but you may be subpoenaed for a null motion. Make sure you save all these, and in theory, I suppose I could still be subpoenaed for one, although the last one I think that I wrote out was in 2016. So the possibility would be very remote, but it's still possible. But yeah, I mean, that was like a local form DWI findings checklist, and we would write the name of the person. It kind of looked like this. Anyway, that's one example. DWIs are not, to my knowledge, subject to expunction, even if someone's found not guilty. So I think most of these would still be public record within that person's, court file. But in any event, without going, of course, into any specific case, yeah, I mean, there were just certain findings that needed to be made, things of that nature.
Yeah, that's very interesting. I don't know how many different offices use that kind of checklist or something similar, but that's, I mean, anytime you're again, maybe different in counties where there are like primarily, only lawyers that are kind of going into this role. But I think that kind of like a checklist orientation on something as important as a first appearance is a really powerful way to make sure that nothing is getting missed, because there are a lot of, there's a lot happening in an initial appearance, even though it goes by relatively quickly on a, DWI first appearance. There's a lot going on. And so when the person was brought before you, typically they had already done breath testing or at least, we're in the process of getting blood, I'm assuming. What was kind of the interaction once you had made that determination about probable cause on the charge? What did the initial appearance kind of look like with the person that was charged?
Well, I mean, we had a conversation, and sometimes a somewhat lengthier conversation than you might imagine. And so that was kind of the unique position of being a magistrate, coming off of being a prosecutor who generally could not talk to the accused and
Yep.
Avoided it at all costs for ethical reasons, to being put in a position where, you not only found probable cause for this person to be charged with the crime, it was your job to then talk to the person.
Yeah.
And, of course, talk to law enforcement too. So you kind of really got to talk to every participant in the system, including, being the judicial official. So anyway, I found it very eye-opening, and you kind of, at least from my experience in having interned at that point in Durham and in Wake County, you kind of saw the trajectory of certain cases. What I mean by that is, like, if you had a .08 in Raleigh, it was probably going to be tried. Now, I mean, these were not necessarily things that I was thinking about, but, when I look back over the records that I kept, maybe they were things that I was thinking about. I mean, you had a .08 that was, and I'll call it just a vanilla .08, right? With basically not much else. I mean, no wreck or anything. Somebody just pulled over at like 1:30 in the morning, and maybe they made admissions, maybe they didn't. They've got no criminal record or limited criminal history. I mean, you're looking at a written promise. And actually, for a whole lot of folks, you're looking at a written promise. Now, I mean, one of the things that the magistrate has to take into consideration, and this was something that we were, and I think, Jake, you and I talked about this, something that we were somewhat hyper aware of in the magistrate's office in
because of Noel. And tell a little bit about that, kind of go down that path in terms of what impact that played at the time you were there.
Yep. Yes. And I think this plays into at the time we were there, and I think it's helpful to practitioners now, having reflected on it since you asked me about it. So yes, Noel, State v. Noel came out of Wake County, Raleigh. And some of those magistrates, who were involved in decision making at the time that Noel came out were still magistrates when I was there. So there was an 80-year-old man, Ray Briggs, awesome guy. He was still working there. Several other people, I could name them all, but I won't. They were all great. And anyway, just having the perspective working with them was really cool at the time. That was before the 72-year-old mandatory retirement age law was applied to magistrates. So I was still able to work with magistrates before that law was applied to them. And so I think Ray ended up having to retire because of the implementation of that law. But in any event, I worked with a lot of older magistrates, worked with a lot of younger ones. But yes, so one thing to look out for as a defense attorney, the detention of impaired driver. So 15A 534.2, 15A 534.2. Basically, whenever someone's brought before you, let's say you're a magistrate, you found probable cause to believe that the person has committed a crime, that being DWI, well, it's then your job to set their conditions of release, right? So a lot of times, release somebody on their written promise. Well, there was the written promise to appear in court. Now, if they had other pending charges or something like that, then you might think about putting a bond on that person to ensure their appearance if they'd had failures to appear, something of that nature. But detention of impaired driver was really a statute that was carved out to apply specifically to individuals who, at the time of their initial appearance, were so unruly, so impaired, so forth, as to pose a danger to the public. So look out for this. Look out for magistrates and it's just something to be aware of, I think, for defense lawyers. Make sure that the magistrate, if they have a genuine concern about that person's risk to themselves or to others in the public based on their level of intoxication, make sure that the magistrate actually did the detention of impaired driver form and didn't kind of like go around that process by just setting a secured bond. And a lot of times, one way to uncover this as a defense attorney is just looking at the release order. Pull the release order out of the file. And if it says, 1,000 secured, and then in the comments information, it says, defendant blew a .20 and was stumbling. Well, that may or may not be true, but that might not be a reason for a secured bond to be imposed, right? That would be a reason for a detention of impaired driver form to be filled out and for those conditions to be imposed under 15A 534.2. And if the magistrate did in fact fill out the detention of impaired driver form, it's really important that the magistrate make specific findings. So I looked back at some of the findings that I made, and it was, defendant was stumbling, strong odor of alcohol during initial appearance, defendant seemed unable to understand where he or she was, that kind of thing. I think sometimes that there will be ways to circumvent the detention of impaired driver rule when really it should be the detention of impaired driver form that's being imposed. So, okay, written promise, this person has no priors. We don't believe they're going to fail to appear. Maybe they blew a 20. And so when they're in front of the magistrate, we've got some concerns about their safety. But those concerns sort of dissipate over time as the alcohol metabolizes out of their body. And so that's something to look for. I think in the Noel case, some of those concerns were implicated. Detention of impaired driver didn't really exist at that time.
I don't think that existed. That's definitely a form that I a lot of times see either not filled out or not filled in it's either missing altogether or the space under the clear and convincing evidence supporting detention is basically blank, even though there's a signature at the bottom or whatever other kind of boxes on the form are checked. And, there's a, this isn't something that I've particularly personally litigated, but, it is a little bit of like a gray area in terms of what specifically makes somebody a danger to themselves or to others? Is there, some proclivity to, DWLR, right? Like if you see that on the record or something, driving with revoked license for impaired revocation, obviously it's like, well, maybe this person doesn't respect having a license. But I think, one of the interesting points that's made in Knoll, despite all of these defendants having a high alcohol concentration, is that, they could have gotten somebody else to come and pick them up. Somebody could have called like a taxi and basically had like a taxi driver, like to take them home. And so there is this, I think, gray area that exists in terms of, what signs and indicators are that someone is impaired versus like what signs and indicators make somebody a danger to themselves or to the community. Is somebody going to fall on their face? And I've had a couple of clients that have been released where maybe they shouldn't have been. Like I feel like the general tendency on a lot of magistrates is like, I'm just going to release, like that, this is, and again, obviously this is a very much a generalization, but knowing Knoll and like that's implications, I'm going to just kind of get the person on their merry way. And I've had a couple of people that have, been released at 4:00 in the morning and there's nobody that can come get them. And they're standing outside freezing and they're complaining about that to me, or that, they ultimately, stumble and fall after they've been released because they're still intoxicated. And so there is this like, where is that line in terms of somebody that's impaired, but not a danger to themselves or somebody else. It's not very, very clearly delineated, intentionally, probably. So,
yeah, and this is how I would compare it, Jake, just to take my legal hat off. If you've ever been to a bar sober,
yeah, yeah,
then and
yeah,
and I say that because I was 26 years old when I became a magistrate, and so I was fresh out of law school, and but that perspective or that experience was valuable. I mean,
yeah,
if you are sober at 3 a.m. and you're talking to somebody who may or may not be, sometimes those experiences, can lead you to make certain decisions, right? I mean, some folks are, okay, their BAC tells the story like 0.08, 0.09, 0.10, 0.11. You converse with them, you have that conversation, that they pretty much get it, versus somebody who might be like 0.20 and has been maced or something of that nature. You may have other charges in addition to the DWI, like assault on government official. Then it becomes somewhat easier to actually just impose the secured bond for other reasons. But not always. I mean, sometimes you might do a detention impaired driver in those cases too, and I certainly have examples of those. But some of the main things for practitioners and I mean this for criminal defense lawyers, make sure that there are actual facts. If you have a detention of impaired driver situation, make sure that the magistrate documented the facts which led him or her to believe that the person would otherwise be a danger to him or herself or others should they be released, and not just conclusions. So make sure that there are objective facts. There's something else that I did was always make a time, the time that I saw the person, I always documented, and then put another time, bring back before the magistrate, whether it was me or somebody else, at a certain time, 3 or 4 hours, however long it would be. So, look for those things. Look for, make sure there are facts, objective, I guess I should say subjective facts that would lead you to believe the objective conclusion, and then make sure that the magistrate also documented a time for which the person should be brought back before the magistrate again for a second look to see if they've sobered up. And most of the time, 9 times out of 10, of course, they had sobered up 3 or 4 hours later, to a point where I felt confident in releasing them from the impaired driver hold.
And the statute, and I don't know when this became part of the process, now allows a magistrate to give a portable breath test to a person charged with driving while impaired, to determine alcohol concentration. Was that something that was in use in Wake County? Was that something that was ever used for determining release purposes, or was it more just based on kind of conversation, physical appearance? What did that kind of typically look like?
I never used that statute, and that sounds very useful. I never used it. If I ever held somebody under a detention of impaired driver, I just made sure to put a time on it and then saw the person again. And I mean, most of the time, I mean, I give the example again of, the sober person who's interacting with someone who might be impaired. It's usually pretty distinct, as to
Yep.
how impaired that person might be. And, the person gets better, gets better over time. And it's pretty obvious. So
What was in terms of kind of the process, if somebody was completely, wasted when they came in front of you, what did that look like in terms of would you conduct an initial appearance then, or delay the initial? How did that part of it work? Because I'm assuming there's some people that literally you can't get a word in edgewise, and there's no, you can tell that there's no understanding of what they're being told on that side of things. So how did that play into the analysis from your side of things?
I never held anyone in contempt. So I'll just go straight to that nuclear option. And,
I do think that's and again, I get that there's probably some just terrible assholes when you're standing on that side of the glass, but it is one of those things where I feel like going that route with it for somebody that's, again, wasted, it's kind of like, that's why they're here in the first place, so it does seem a little bit like almost silly to kind of go down that route, because it's just like this is, who knows if this is the real person that I'm interacting with at this point. So
yeah, there are certainly times where I would delay the initial appearance, and that's authorized by statute, of course, not just in DWI cases, but in all cases in which the magistrate conducts an initial appearance, which this is about to be changed by state law, I think, in a pretty big way. And not to segue into that too much, but it's my understanding that there was a session law passed this year in 2023, which will basically authorize only district court judges and above to set conditions of release for certain persons, including people who are arrested for crimes, for alleged crimes, when they also have another alleged offense pending. Well, that's a whole lot of people, And when I was a magistrate, we just pretty much set conditions of release on everybody. Not the only pause there was domestic violence situations, and even then, and we can go into this if you want to. Even then, certain conditions of release, it was debated within our office whether certain conditions of release could be set. I decided to set some. That ended up going up to the Court of Appeals, and it ended up being upheld that the magistrate could, in fact, set some conditions of release during the time period.
Made North Carolina case law as a magistrate. Pretty cool.
Yeah, that was cool. It really made me feel like public service was, well, I already knew it was rewarding, but to see it, go up and to make law in a good way, I thought that was even more rewarding. But anyway, there was a law passed recently, which I think is going to restrict magistrates to a certain extent, and we'll have to see how that plays out. But to answer your question, that there was a provision of law which allowed for the delaying of an initial appearance if somebody didn't understand what was happening. But I saw folks who were arrested for discharging firearms into occupied dwellings allegedly. Of course, the domestic violence situation. I mean, you name it, every crime. I saw folks for that. The most common circumstance where you might delay an initial appearance would have been during the DWI, but then that really played into the detention of impaired driver hold. So like if it became apparent that I needed to delay the initial appearance for somebody who was arrested for driving while impaired, then I might as well go ahead and fill out the detention of impaired driver hold rather than delaying the initial appearance. So I would go ahead and start making those findings, like Mr. Smith is unable to comprehend the
Yeah. Yeah.
basic personal question, like where he unable to answer, where he lives, things of that nature, and then go ahead and do the detention of impaired driver. And so that's where I say for practitioners, look out for ways where the magistrate is trying to, not that the magistrate is doing anything wrong, but just look and may play into null. Look out for ways where the magistrate is trying to circumvent the detention of impaired driver hold, because I think that the General Assembly very clearly enacted detention of impaired driver for those circumstances under which somebody who is arrested for driving while impaired doesn't really understand what's happening, because they might be at risk to themselves or the public if they're released. And so that's when, in my opinion, the magistrate should be filling out the detention of impaired driver form. And in that niche circumstance, you don't have to document it so much. If somebody's arrested for discharging a firearm in an occupied dwelling and they're impaired, yeah, you want to document that, but that can be a reason to delay the initial appearance. But if it's a DWI, then that needs to be documented very specifically, in my opinion.
And then in terms of, communicating to the defendant about their right to get independent testing or to contact, counsel or family members or other people about the case, what advice would you give in terms of like practical points on that end? Is that something, that from a real-time perspective in the jail, that there was phone access for people that were charged to make calls, in Wake County specifically, in terms of kind of attack points for defense lawyers to look into? What advice, if any, do you have on that side of things, Adam?
That's a really good point. So, once the police officer reads the defendant their implied consent notices, and things of that nature, yes, I really do think it falls on law enforcement at that point to make sure that during the 30-minute window, if the defendant elects to contact somebody, that the defendant is afforded the opportunity to contact someone. Now, the magistrate's really not involved in that process, at least in Raleigh. That's
right.
That's mainly, law enforcement, right? Because that could take place on the side of the road. For example, if there's a crash, the police officer responds. The person can't be taken in front of a magistrate. They're going to the hospital. The police officer wants to draw their blood. Hey, here's the form. The person who's involved in the crash and who's charged DWI, do you understand this? Do you want to call anybody? The magistrate doesn't get involved in that,
right.
Potentially until way later, or maybe never, depending on if the person's cited and released. But yes, it is important for the magistrate to explain to the person who's charged that they have the right to have an alternative test and things of that nature. And we had a process for that in Raleigh too. You've been charged with driving while impaired. And there's actually an AOC form for this too. And so every once in a while, people would scribble in a name and a number and things of that nature.
Right.
Yeah, look for that. Make sure, and I believe it was called Implied Consent Offense Notice. I believe that was the name of the form during the time that I worked as a magistrate from 2014 to 2016. So just double check and see if that's still the AOC form. But yeah, sometimes I would call folks, hey, is there anybody that you want me to call to let them know that you are here? Put their name and number on here. And, I would help people out sometimes. I don't know their number. I don't know their name. I forgot. I'd call back to the jail. Hey, jail staff, can you pull this person's phone? Did they put any, is this name or number in the phone if they could access the phone? That became a whole nother area of law that developed. But search warrants and searching phones, all about the same time. But yeah, to answer your question, yes. I think that defense attorneys should look for that. Make sure that if the person, if your client's telling you like, hey, the magistrate was really nice. He told me that I could call anybody, but then I never could get to my phone or whatever. Definitely pay attention to your client. Look and see if the magistrate did the implied consent offense notice. Look over the magistrate's paperwork. Fortunately, I only got subpoenaed for one null motion. And, I would tell you who the lawyer is, but I won't.
I actually kind of have a question about the subpoena situation, because, I've had a couple of times where I subpoenaed a magistrate and got a letter from the Attorney General's office basically moving to quash the subpoena. Typically, this resulted in a phone call at some point with one of the, I think it was assistant attorney generals that was kind of asking, what are your, why are you calling the magistrate? Because I think that the concern was getting into the kind of judicial discretion. So did you guys have any conversation with within training or with the attorney general's office in terms of if you got subpoenaed on a case, what the process was for that?
So yes and no. In Wake County, the local practice was, and I don't know if this traces back to Knoll as to why magistrates were kind of put under the gun in that county. But in general, if the magistrate was subpoenaed by a defense attorney in Raleigh, the magistrate had to go. And
Okay.
we didn't call on the AG's office to come up with an immunity defense or anything of that nature.
Okay.
And I don't know if that traces back to Knoll. I wouldn't be surprised if it did, but. In any event, I was only called one time, and the defense attorney was a former magistrate himself. Really good guy. But I took my whole stack of findings for that particular case, along with some other materials. I think there's a really good publication that I would encourage any practitioner to look at. It's called "What's Knoll Knoll Got to Do with It?" Put out by the School of Government. What's Knoll got to do with it? And I had that, of course, in my stack of materials too. And I remember the lawyer asking if he could see my stack of materials. Sure, here you go. And he withdrew his Knoll motion. And I can't remember if they pled guilty after that or what happened. But and it was after a night shift, so I had worked all night and was in court the next morning. And
it's a tough time to get called, because I mean, if you're doing the DWI first appearances, that a lot of times means you're working late at night, and that in court don't really match up in terms of the schedule. That's a tough. I feel like I've very rarely had a magistrate that's come into court that hasn't like just gotten off work, and you can just tell it's like, man, I've been up for 24 hours. I'm ready to go. I'm ready to go home.
yeah. I'll tell you something that I thought about that was interesting, as I was reflecting on the questions, that you sent to me and things, was that being a magistrate in some ways, and I'll just say this to other lawyers who might be watching, and in some way in Raleigh, especially, in some ways justified my like working overtime when I became a prosecutor full time and then became a defense attorney full time. It was almost like, well, I've worked mid shift from 2 p.m. to midnight. Right. I've worked overnights from 9 p.m. to 7 a.m. and it was completely, justified and actually required of the job. Like it would have been, failure to discharge duties of office, had I not done the overnights and the mid shifts. And so when I became a, full blown practitioner practicing law, I kind of adopted the same mindset, and, work can be done at any hour, basically. And so while that's true, I would just caution folks, don't, don't, at least for me, it was interesting. It was like, well, I can work mid shift. Work can be done at any time, and it's a noble thing. But I think that work-life balance is extremely important. And so, while I did learn a lot by working at night and working mid shifts, don't forget as a lawyer that you need to have work-life balance. And, I think that's,
I think that's a huge point. And I think, along those same lines, in terms of your time as a magistrate, how did that kind of impact then, your kind of personal philosophy of how to handle a case as a practitioner? What were some of the takeaways from your time being a magistrate?
Well, I mean, it really helped for me to have known literally where the case was born. The genesis of the case was with one or two people talking about things. For example, when an officer would come to me with probable cause for a warrant for somebody who was not in custody, especially if it was a high profile case or a case which I thought might have potentially have some appellate value. I mean, you just slow down. And I think that's important for practitioners sometimes, is to slow down a little bit. Yeah, and sometimes we just want to, push our way through things really fast. And I think that it's important to go fast sometimes, but also at other times to slow down. I think there are a lot of it's a lot of push to kind of get things done, and there has to be a balance struck between getting things done, getting cases resolved, but also in a way where everybody is sort of protected. Primarily the defendant, right, the citizen who's accused of violating the law, but also like the state of North Carolina, the just every person who's involved in that particular prosecution. Sometimes slowing down can be the right answer, even in the context of the initial interaction with the magistrate. And so, knowing when to move fast versus knowing when to slow down, I think is important in those contexts.
And I mean, you've already mentioned a couple of these things, but maybe this is kind of a good place to somewhat kind of close the conversation. Is what if anything, practice point wise, from your time as a magistrate to now kind of being in the criminal defense seat, what practice pointers would you have based on anything that's kind of going on in the context of the jail during those initial kind of like first moments after somebody gets charged and the officers involved, the magistrates involved, whether it's from a paperwork perspective or, as a criminal defense attorney investigation perspective, or even just from a kind of like practical knowledge perspective, what if any, practice tips do you have based on now kind of sitting in the defense chair side of things?
Well, certainly, like if your client calls you, at midnight or 1 or 2 in the morning, let things play out. I would say, you may provide some level of advice, whatever that advice may or may not be, and I'll just leave that ambiguous, up to the practitioner's own discretion. But at some point, at that point, the government really has that person seized, right? I mean, the police are going to do what they're going to do, more or less, and they're going to be taken in front of a government official, a magistrate, and most likely. And so, to a certain extent, and I think most practitioners do this. I mean, most folks don't have their phone on at 12 a.m. They're not driving to the jail at 1 in the morning. So, I mean, I think most people already are keenly aware of this. But let that play out, because there might be the person is probably going to be fine, especially with the practitioner's advice. But there also could be an error that's baked in there that occurs that may ultimately serve your client in the long run, to let that error occur. And then hopefully not. I mean, that's not something that's intended by the system. I think everything is most of the time going to work out fine. But ultimately, once you have the time to Monday morning quarterback it, that's when you're going to be able to find those errors, and if they exist, and things of that nature. So, yeah, I mean, I'd really scrutinize the paperwork, and there's really a lot to be learned from it all. But just remember that the magistrate and the police officer and your client, whoever your client is, they really had a face-to-face, person-to-person interaction. And however you unpack that, however you unpack the paperwork and your client telling you what happened, I think can be very useful.
Well, that's awesome. I think that, again, this has been such a helpful conversation, Adam, in terms of just having the eyes to kind of like see what this looks like more in real time. And if anybody that's listening has a case question that they'd like to kind of get your eyes on, that is related to null motion or magistrate situation that went on in their particular location, is it okay to share your info and have them give you a call? Is that something? Is that all right?
Absolutely. Yes, of course.
Yeah, I mean, I think it's just so helpful to have somebody that's kind of been sitting in that role to kind of, be able to identify, what kind of is the ideal paperwork in terms of how this should look, and be able to bounce any questions off you. And again, I'm always happy to take a call from somebody that has a case situation going on that they want to discuss. But make sure that you reach out to Adam if you've got a situation that involves Noel or some other kind of related question. I know that Adam, we've only had a few conversations now here, but I feel like you're definitely like in the weeds on the law side of things and get a kick out of it. So I think you'd be a fun person to bounce a case off of. So
Thank you, Jake. I really appreciate it. It's fun being on the podcast.
yeah, really appreciate the time, Adam. I hope you have a great rest of the afternoon.
Thank you, sir. You too.